This was the scene this past hour. High security at the courthouse. 4 men accused in an alleged mob-style hit in Little Italy are inside that court wagon being escorted out by emergency task force vehicles on either side, being taken back to detention. Now, this was for day one of the trial in a daring daylight murder in Little Italy almost exactly 5 years ago. Now, security inside the courthouse is also extremely tight, which had us questioning just what kind of protection is being offered to the jury. On June 18, 2012, while sitting at a crowded patio in Little Italy, John Raposo was shot 4 times in the head by a man dressed up as a construction worker. The Crown today laid out its case against 4 men accused of orchestrating and carrying out the hit after a falling out with the victim over plans to smuggle 200 kilos of cocaine into the country. Now imagine being the jury sitting in that courtroom, tasked with deciding the fate of men accused of masterminding a mob-style assassination in broad daylight over allegations the victim was a rat.
Typically, it would be address and occupation.
David Butt is a criminal lawyer, and this is called a Form 9. It's the actual paper that outlines the names, addresses, and professions of each juror, which is usually available to the accused. Are there provisions in place for jurors after a trial or even during a trial to offer them protection if they feel at risk because they're deciding the fate of someone who could potentially harm them?
Sure, that would be an exceedingly rare case, and frankly, it doesn't happen.
But Ontario's Attorney General says judges do have certain powers of jury protection.
If there has been a case where it's gang-related or mob-related, or if a juror feels that they may be unsafe, the judge who's presiding over the case has opportunity to protect the identity of the juror.
In fact, the trial judge in this case has opted to shield the names of the jurors from the accused. They are listed simply as juror 1 through 12. The Federal Justice Department has recently been handed recommendations on the safety of jurors and calls for the criminal code to actually be changed so that jurors are only ever identified by their numbers and to control access to their personal information. The sensational 2002 mob trial of Maurice Montboucher in Quebec set a benchmark for juror protection. All documents about their identities were sealed. Jurors were only addressed by number, and measures were taken to prevent jurors from being followed. And this, a ban on courtroom artists drawing the jury, has been adopted in trials right across this country, including the one that began here in Toronto today. Despite the increased security inside the courtroom and outside today, legal analysts say the job of a jury is low risk.
Much as people might think that, oh gosh, you're doing a mob trial, your life must be in danger. Actually, the contrary is true. It's not high risk at all. Frankly, the people who are most at risk are witnesses from the community of the accused who have perhaps betrayed the accused. But even those, that's very rare. The juror is the last person, frankly, who's in the line of fire. You get rid of a juror, and there's simply another juror to replace that person. You get rid of a witness, and the case goes away.
Now, if you've ever been into the courthouse before, you know that when you first enter in, you go through a metal detector. There's added security precautions here for this trial. 2 separate screening stations are set up outside the actual courtroom, and in the body of the court, officers who are not in uniform. This trial is expected to last 10 weeks.